Good morning, everyone. It is Sunday, October 22, 2017. That's my cat in the background. If anybody needs to make a donation or you'd like to reach out to me to ask me questions regarding the donation and what you're going to get, for my paperwork, the email is rick 0327 at me.com. All right, so yesterday, we had a pretty good video uh, talking about, filing a writ of mandamus, and um, I'm big into these writs, um, and I'm going to be doing a video on the writ of habeas corpus as well. What we're doing is when we file these writs, we're asking the courts, well, we're demanding basically that the courts take a look at the facts and the evidence and and make a ruling based on it. Okay, so yesterday I did the video about a writ of mandamus, and I showed you guys the website from an attorney, and it's easier. I there's also a good. I didn't use it because I forgot. Actually, I just remembered now. But it was another an attorney here in New York, and he touched on Article 78. Again, in New York, and Article 78 is a writ of mandamus. You saw yesterday that he was in California. It's called a writ of mandate. Okay, they took away the Latin mandamus and they just made it into mandate, but it all means the same thing. All right, and what it does is it's good to see when an attorney does it, because an attorney they're gonna they're all about rules and procedures, and so by following their rules and procedures, it's easier for us, even though we're, and you can't see it right now, but I'm putting my fingers in the quotation, or pro se, or propria persona, any of those. We're not an attorney, so if we just follow, we just follow their lead. We prepare our own paperwork, and we try and proceed. Now, the video I'm doing today, if you see here, all right, this is from National Liberty Alliance.org. They're a common law group they're fighting. They've sent notifications to all the courts, everybody, all the senators, everybody, because we're a common law country, all right, and the common law has been removed from the courts purposely. Okay, I went through my common law phase, 3 years ago, 2 years ago, and I was stonewalled. That's the federal case I keep telling you guys about, and I was completely stonewalled. And uh, there's a decision, United States versus Williams, 1992, where Justice Scalia stated that the common law grand jury is the fourth branch of government, and that it's not controlled by the court. Okay, the grand jury is controlled by us, but over a series of time, I can't tell you, how many years, but it's common practice that the courts are controlling the grand jury. And I know because I've testified in over 50 grand juries myself, being involved in many felony arrests as a police officer. So I can tell you how, it's very, there's a saying, a good attorney can indict a ham sandwich. Okay, it's not hard to get a felony indictment. All right, it's very easy. So, but that's because they're controlling it. Now, in reality, you and I, we should be able to just show up one day to the court and say, yeah, here's my evidence, here's the facts. I want to issue a summons, and I want to run my own grand jury. They won't let you do it, but that theoretically you should be able to under the Supreme Court decision, the United States versus Williams from 1992. And as I said before, Justice Scalia himself said that the fourth branch of government is the grand jury system. Okay, but unfortunately, this stuff has been, taken away from us. The bar association is a monopoly that runs the court system. Um, you can't even plead a case in front of the United States Supreme Court, the highest court in the land, without an attorney. Okay, they didn't have licensed attorneys. Well, first of all, they're not really licensed. That's all bullshit. It's a membership club. That's all it is. Okay, it's not like getting a license for being a plumber or a driver's license. Okay, it's a membership club. That's all the bar association is. It's a big membership club, and they're all out for themselves. It was the bar association that created this whole scheme of child support. This is what I was telling you guys yesterday. This is why, uh, my opinion, and a lot of people smarter than me on YouTube will tell you the same thing. You'll if you put the work in, or you reach out to somebody like myself, I'm Osiris. People, have an idea of what we're talking about, and we prepare documents for you. You're gonna do better by yourself, because if you hire an attorney, you're gonna get screwed. You're still gonna pay child support. You're still gonna owe arrears. All right, and you're gonna be out that money you paid for the attorney, because the attorney is not. If you, I had a couple of people, months ago, who were, using my paperwork and still holding on to an attorney. And I was like, well, what are you doing that for? Because he's like, well, I mentioned this to my attorney. And I'm like, buddy, the attorney is going to lie to you. Yesterday, I referenced in my video about when I had a hearing for my workers' compensation carrier. Now, what happened was they were sending these income withholding orders to my workers' compensation, to my pension system, and my Social Security. So they were taking my money from three income sources. They were taking $6,000 a month from me for 4 months in a row. I couldn't get them to stop. So anyway, workers' compensation is another scheme. I have lawyers that's all they do is that. It's another kangaroo court. All right, it's not, it's a scam. So I called the attorney that represented me through my whole process when I was going through my retirement. And I'm trying to explain to this guy over the phone that the income withholding order is not a court order. And I dealt with this lawyer. He was a seedy guy, but he would not understand what I was trying to say. He refused to understand what I was, and this is a guy, by the way, that I was on a first name basis with. His name was Richard. I used to call him Richie, and I dealt with him for a while. He called me Rick, and I wound up hanging up the phone on this guy. I got so angry because he's like, yeah, but it's still a court order from the family court. I'm like, no, you don't understand. It's not a court order. It's not issued by a judge. I go, why can't you understand what I'm trying to say? I go, either you don't want to understand it. You're just feigning ignorance with me. These attorneys know what a court order is. So I was trying to explain to them, it's not a court order. It's not issued by a judge. So how can that override my divorce judgment that says I'm not supposed to pay child support by income? In my divorce agreement, it says I'm not supposed to pay child support by income, or it's called uh, income execution order. An income execution order is actually a court order. It's supposed to be signed by a judge. An income withholding order looks just like it. It's a forgery. Okay, I mentioned this in my past videos. I'm like, what a coincidence that an income withholding order looks just like an income execution order. Okay, there are ways that the court can issue a proper money judgment if you waive your rights to a trial and all that stuff. You know what I'm saying? If you go along with the rules of the court, it can be done properly. You can't be, deprived of money by income execution order. If you go along with, if you have an attorney. Obviously, if you have an attorney, you already submitted to the jurisdiction of the court. But anyway, let me move on. So these attorneys are not gonna, well, when I got to that story, I was saying to you guys about, guy has my paperwork and he's still dealing with an attorney, and he's running this stuff by an attorney, and the attorney's, well, no. I'm like, dude, you got to make up your mind. Either you're going to use my paperwork or you're going to use the lawyer. You can't do both, because it ain't gonna. I'm telling you, it ain't going to work. You're going to hand my paperwork or write your own paperwork and hand it to an attorney and say, all right, listen, I want you to file this, and that's it. Because theoretically, you could do that, because in my very early stages of my case, I had an attorney, and actually she tried to get the case dismissed, and I had to sign a verification letter that, all the words and shit she was writing, that my signature was, I'm agreeing to what she was writing. It's called a verification form or letter. Now, while I'm on that subject, we've talked about in the past that every case before the court, there has to be an injury in fact. Now, a lot of you are respondents, and a lot of you, the petitioner is the state of Washington, the state of Virginia, or the state of Commonwealth of Virginia, the state of whatever. Now, how can the state of Washington, the state of, Commonwealth of Virginia, any state, the state of New Jersey, how can they be an injured party? Or what you should be asking for, along with the proof of an injury in fact, where is the verification letter? Now, I'll explain. Maybe some of you have done this in the past. Let's say you've gone to a police station and you want to file a police complaint. They'll have you sign the letter, or let's say you were a victim of a violent crime. You go before these detectives. I know because I've done this, and you'll take your sworn statement, and on the bottom you sign under the threat of perjury. That's a sworn affidavit of verification. So that's an item of evidence you should be asking for. Okay, a verified letter of a sworn under the threat of perjury, because if some person's going to walk into a court and go to a clerk like they do in family court and start this whole bullshit, it's going to cost you a lot of time and aggravation. Well, at the very least, there should be some evidence, and there should be some kind of signature under the threat of perjury, under the threat of false statement. Okay, they do that all the time with the police department, but they don't do that. Because why? Because it's really what they're doing is they're starting the clock on the clock is rolling. They got to get the money from you as soon as possible so they can receive their federal funds from the federal government on a Title 4D. That's the reason why you don't get a trial by jury. Okay, that's the reason why they don't even mention that to you. That's the reason why in my affidavits, I send you guys folder, not folder, when I email you a folder of affidavits to file before the first court appearance or your next court appearance. And what we do is we're demanding a trial by jury. Okay, you're entitled to a trial by jury under the 6th Amendment and the 7th Amendment. The 6th Amendment is if you're facing criminal charges. The 7th Amendment, if it's a civil proceedings of a controversy at common law of $20 or more. Okay, so you're entitled to it. Now, as recently as 2015, the Supreme Court, they cited the case Murray Leasing versus Hoboken Railroad, or whatever it is, and it says that deprivation of property in the course of due process, which is synonymous with the law of the land, is, you know what, I'm doing this, I'm funny, I got this right in front of me, all I gotta do is this. Okay, hold on a second here. Let's just go to my memorandum of laws to show you. I do things hard sometimes, excuse me. It'll load up eventually. Okay. All right, so, all right, now here, I have the definition what liberty is. This is a Supreme Court case, 1923. Writ of habeas corpus is not just for if you're jailed. It's also if your liberty or your property is restrained. Okay, so if you're being restrained by one of these fake court orders, you could file a writ of habeas corpus. And they define what liberty is. Liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire knowledge, to marry, okay? Bring up your children, all right? How many of you guys are dealing with this custody stuff, right? Here's your remedy right here. Also, Troxel versus Granville. Okay, another one. I don't have it in here because I didn't need to use it. This is the case right here. Murray's Lessee versus Hoboken Land and Improvement Company, 1856. Okay, the words due process of law were undoubtedly intended to convey the same meanings as the words by the law of the land in the Magna Carta. Lord Coke, Magna Carta is 1256, something like that, says they mean due process of law. The constitutions which had been adopted by several states before the formation, okay, so before we, had the Declaration of Independence, the Constitution, in the 1700s, states already had their own constitutions, okay? All right, so the Constitution which has been adopted by several states before the foundation, following the language of the Great Charter, right here, the Magna Carta, more closely generally contain the words, but by the judgment of his peers or the law of the land. Okay, so you cannot be deprived of property unless by a judgment of your peers. How does that happen? By a trial by jury. Let me see if I can find that case. I don't have, but again, it was cited as recently as 2015. So they're still citing that case. This case I just showed you just now. Okay, so that's the law of the land. That's due process. All right, so I'm done going over that stuff right now. Let's get to the real reason I started this. Okay, the problem at hand for a lot of you out there, and it happened to me, I talked about it yesterday, I touched on it, is the clerk's office. Okay? They are very, very, very difficult. And how can you get a remedy if you cannot get your pleadings into the court? Okay? So what I did was, I prepared how to file on demand. Okay? Comes now, your name is demanding the clerk of the court and employees to perform the ministerial act of accepting all pleadings from the undersigned, your name, blah, blah, blah. Now, remember now, what did we do yesterday? We were talking about a writ of mandate, writ of mandamus. Now, believe it or not, you could file a writ of mandamus to have the clerk's office accept your paperwork if they're if they're refusing to accept your paperwork. Let's hope it doesn't get to that. That's what we're trying to do right now. But believe it or not, that's their job. Okay, under Federal Rule 5, their duty is to accept pleadings. It doesn't say anything about them reading it. It doesn't say anything about them understanding what your intention. Whenever they do that stuff, and a lot of my people get this letter, oh, we're not quite sure what you're trying to do. What they're doing is they're feigning ignorance. That way you cannot accuse them of obstructing. Okay? Because that's what they're doing, plain and simple. Because a lot of you live out of state and you're trying to get the pleadings through the mail. And they send it back to you and they're like, well, we don't understand what you're trying to do. Meanwhile, it's, again, I over-explain things. So it's not like it's written in plain English. We don't use big words. We don't use legalese. We use common words in the English language. I try to keep it as simple as possible. What they're doing is they're feigning ignorance. Okay, but it's not their job to understand that. Usually in the upper right corner of pleadings, right? Like right here, look. Oh, I'm sorry. This one right here. Okay, right here. There's your attention right there. Memorandum of laws in support. That's it. What are we trying to do? There it is right there in the upper right side of the document. That's what we're trying to do. So technically, they get this. All they should be looking for is they go all the way down here, and I didn't put it here because I didn't finish it. There should be the line with your signature. That's it. They shouldn't even be reading all of this. That's not their job to be reading all of this. They should just make sure it's done in a, in the proper form. And some of them are getting out of control. We're like, well, it's not done the way we want it to be done. Listen, you could write this in friggin' crayon, and they should accept it. You could. One guy did. There's a case. I can't remember. One guy did a writ of habeas corpus written on toilet paper from a prison. Believe it or not. So let's say, like, God forbid, somebody was shot and they're dying, and they write down, who shot me. You think they're going to say, well, we can't accept the papers because it wasn't written on the right, it wasn't done in the right procedure. You understand what I'm saying? Yeah, I got away with murder because it wasn't done properly. It didn't follow the procedure. It's just their way of being difficult. Remember, the courts worry about all the, how much paperwork they got to deal with. They try and turn away as much paperwork as they can to lighten their load. Because I guarantee you, they'll hear it from the judge. The judge will be like, "What are you doing accepting this?" I'm just based on my experience and the experience of the people that I'm trying to help. I know that that's what's going on. Okay, so all right. So what this is doing is we're telling them to accept the pleadings. I don't have to go into all of it. If you guys want, I'm doing it nice and slow. You could freeze it. I tell them. Basically, the undersigned is permitted by constitutional law under the First Amendment to be free from governmental interference to tell the undersigned how I should write my pleadings and refrain from ordering the undersigned on how he or she should write his or her own pleadings without using court paperwork, which confines the undersigned to writing on a few lines, which obstructs us from, describing properly what's going on. You can't explain things in a couple of lines. Okay, so then I write the following violation of Title 18 will be filed against any clerk or employee of the clerk's office who willfully refuses to accept and forward the pleadings, offers false information to hinder, delay, or prevent the communication to a law enforcement officer or a judge. All right, and I don't got to go into all of it. Here it is. I showed you yesterday. I said it was 2007. It is. But this is the one for the clerk's office, 18 U.S.C. 2071, right? Whoever, being a clerk of a district court of the United States, willfully refuses, and this is any court, by the way. So a lot of these clowns play games. Oh, this is federal court, this is state court. I guarantee you there's a state procedure that mirrors this. Okay? Concealment, right? 18 U.S.C. 1512, tampering with witness, victim, and informant. Okay, under B, prevent the production of a record document in an official proceeding. And I got it from these guys. These guys have very good paperwork. The National Liberty Alliance, they have really good case laws as well. All right, so then now we have this, right? So let's say you hand them this, right, with your paperwork. And let's say they're still difficult, right? This is what I put together. Well, being that they like to give us paperwork, but that's only a few lines, what I did was, okay, here, reasons for not accepting pleadings. Comes now, your name is demanding the clerk of the court and employees to accept all pleadings from the undersigned affiant. All right, you're the affiant. And then forward it to the appropriate court. Please describe the reasons for not accepting these pleadings. Okay? So now we got them writing stuff down. And of course, you're going to hand it to them. And you put your name here, and we're going to add another line down here. Have them sign it, and most importantly, you want them to timestamp it. So what you should go to court is with 2 copies of this and 2 copies of this. That way, one is for them and one is for you, and you want them to timestamp it. What I would do if I was you when you're doing this, audio record it or visually record it if you can. All right? Bring your phone in there, sneak it in there. Okay? All my recordings that you see in my videos, I didn't ask for permission. I just did it. All right? Now, last time I was in court, the magistrate was reading out uh, some memo from the chief judge because, again, they all know my videos. But I never got in trouble because guess what? It's not unlawful. Okay, but they don't like, they don't like being recorded. That's the reason why all these hearings are in a small room. They don't want you to have any witnesses. It's nothing more than a big scam. Okay, and if you pay for the transcriptions, you're gonna read them. You're gonna find out they take. Oh my God, I caught them. Oh my God, I caught them so much stuff. I've been through the ringer with these people. All right. Um, in the comments section yesterday, the guy Josh Ortiz, you'll see it. He's like me. I've been through all of the things. I've tried everything. All right. I tried UCC. I've tried common law. I've tried secured party. I've tried all of these things. And again, I'm not saying it doesn't work. I'm just telling you it ain't gonna work there. The best. Listen. All you have to do is follow their own rules and the facts. The facts are, where's the proof that I owe a debt? Where's the proof that I'm not paying? You're claiming I owe a debt just because I fathered a child or mothered a child. You're saying I have a duty. Well, again, the government has, right? We just said it before, right? I read the case law. The government has no right to tell you how to raise your children. All right? The reason why they claim you owe the money is because supposedly the mother or the father is receiving public assistance. Now, many of us, there's nobody receiving public assistance, but because they get basically 66% or dollar for dollar for every dollar they collect, that's the reason why they force so many of us into into paying by income withholding. That's why so many police and fire and all kinds of public servants are they go for a divorce and the lawyers are trained. That's why I haven't been able to prove it, but I gotta believe that these lawyers are getting a kickback. Okay, they have to be getting a kickback. I just haven't been able to prove it by having their client agree to paying. Just do it that way because that way she can never say or he never say they never received the money. That's what they tell everybody. But the real reason is because the state wants to get their money, and then they won't also tell you that every 3 years they will raise your child support every 3 years. Okay, and they're not supposed to raise your child support unless there's a significant change in circumstances. Okay, all right. So listen, I'm going to shut this down. All right. Again, this is for people that want to get their paperwork through. All right. Anybody that has my paperwork, you can reach out to me. All right, because I get emails all the time. It's very frustrating. I get really aggravated with it. All right. So again, if anybody's interested in receiving my paperwork, you reach out to me. Email is rick0327@me.com. All right, guys. Enjoy the rest of your Sunday.